Hi friends, welcome to the third class of contracts. And in this class, what we are going to cover is the essential of a valid contract. If you remember in the second lecture, I gave you a brief of this. I gave you an idea of this. I said that it is defined in section 10 of the Contract Act, which says essentials of a valid contract. And these are very necessary to make a contract a valid contract. If any of the components, what we are going to discuss today, are not there in a valid contract, it will not be considered as a complete or legally binding agreement. So, section 10, we'll start with section 10 and we will see where it is stipulated at respective sections and their components. And we will see what are the essentials of a valid contract, which is defined in section 10. So typically there are 5. The first is a free consent. The free consent is defined in section 14 of the Act. Second is a competency to contract. This is defined in section 11 and 12 of the Act. Lawful consideration and lawful object. These two are jointly defined in section 23 of the Act. And the fifth essential is that the contract should not be void. The voidability conditions are defined in section 23, 24 to 30, 32, 36 and 56 of the Act. So these are the 5 essentials, as I said: free consent, competency to contract, lawful consideration, lawful object, and the agreement should not be void. So we'll take up them one by one. So we'll go in a sequence because section 10 determines it, and then section 11, it talks about the competent parties, the parties which are competent to the contract. So if you see, there are typically 3 parties declared in section 11 as competent to contract. The first condition is the contracting party, none of them should be minor. So they should be the major. So major, definition of major comes from section 3 of the Majority Act, that the person more than 18 years is eligible to contract and can be considered as a major. The second condition is soundness of mind. The person should be sound mind, and this soundness of mind is again elaborated in section 12, which we will see now. But in section 10, the definition, the competent parties are defined as major, which the reference of which we can take from section 3 of Majority Act. Sound mind, the person should be sound mind, and the third is he should not be disqualified from contracting by law. The soundness of mind, it comes in section 12, but before that we have to see a renowned or considerable or important case related to majority in contract. And that contract in Indian legislation is Mori Bibi versus Dharmadas Ghosh. This is a milestone case deciding, having a decision on eligibility or non-eligibility of a minor to contract. So whenever the question comes on the minority issue related to a contract, we definitely, in Indian jurisdiction, we should give the reference of Mori Bibi versus Damodar Ghosh case. I'll go with the facts of this case now before going to section 12, which talks about soundness of mind for contracting. So in this case, what happened, there was a minor, his name was Dharmadas Ghosh. He goes to a person, a rich person, Mr. Bhumrodat, and he mortgages his property papers to him. Bhumrodat was aware that he's a minor, and still he accepts that, and he makes a contract and give him some amount of money. The person goes back, and his mother, Dharmuda's mother, when she came to know that he has made a wrong contract, she communicates to Bhumrodat that the contract is not valid because the person with whom you have contracted, Mr. Dharmadas, who is my son, he's not a major. So, but he didn't care for that. He gave him the money and he keeps on the papers with him. And he expires. Later, his legal heir, Mori Bibi, his daughter, he comes into picture. And in 1893, Dharmadas and his mother, they files a case on Mori Bibi for the possession of the documents to be returned. Now, the judgment came in 1895, and that was in favor of Dharmadas Ghosh because he was a minor and the contract was void ab initio. Void ab initio means the void since start, since inception. So it was no contract at all. So court gave the judgment in favor of Dharmadas that he was minor, the contract never existed, so his paper needs to be returned. So after this case, the settlement in 1895, Mori Bibi again brings the litigation in 1903. She says, now this time she says, this case was famous. This is Mori Bibi versus Dharmadas, while the earlier one was Dharmadas versus Mori Bibi. So in Mori Bibi versus Dharmadas, she claims that the amount which was paid to him, that needs to be given back to her, at least. But again, the court decides in favor of Dharmadas. The court says that he is not required to return any sum because it is a responsibility of the major person to check all the details when he is trying to or attempting to make a contract with a minor, because such contract is void ab initio. So this milestone case makes it very clear that the contract with a minor is no contract at all. It's void ab initio. So this is related to the explanation of major essentials, which is mentioned in section 11 related to competency of the parties. So the next one is section 12, which is soundness of mind. Soundness of mind. Section 12 says that who is a sound person, who is a person of sound mind. It says that a person who is capable of understanding and making a judgment is a person of sound mind. I'm again repeating it. The only two criteria related to determining the soundness of a mind of a person who can contract is capability of understanding and making a judgment, as specified in section 12 of Indian Contract Act. We can relate this soundness of mind at various places, because this soundness of mind says that talks about the mental capacity of the person at the time of signing the contract. So here, if we go to the illustration, we can see that who is person of sound mind. Can a person who's lunatic, or like who's not in his state of minds, who gets fits, is he fit to make a contract? Yes, because this further elaborates that a person of unsound mind, and if he's occasionally sound, and in such situation of occasionally soundness, he signs a contract, that contract is valid. Alternatively, if a person who is of sound mind, but he's in a state of unsoundness, maybe some force intoxication or something, in that state, if the person of sound mind also makes a contract, that contract becomes void. So this may be something strange to you, because the governing criteria is the mental capacity at the time of signing a contract. So a person, that's why the person who is not mentally sound, but if he makes an agreement or gives his consent to a doctor for some operation, that is considered valid, provided at the time when he has gone through the agreement and signs or given his consent, at that time he should be in a proper state of mind. That is soundness of mind. That is a mental capacity at the time of signing a contract. Alternatively, if a person who's a healthy person with a normal state of mind, but if he's intoxicated, he's not in soundness of mind, and that is proved in court of law, that contract will no more will be a contract. The same stipulation related to soundness of mind and intoxication and minor in criminology, you can relate these with section 82, 83, 84, 5 and 86 from the IPC, because section 82 and 83 talks about the talks about the majority and minority related to the type of offense, while 84 talks about the soundness of mind, and 85 and 86 talks about the intoxication, which can be, if the intoxication is not in the knowledge, like it's without a will or without the knowledge, then it is no more a basis of confirming the offense of the person. He can be easily absolved if it is established that the intoxication was against his will or knowledge. So those excuses in criminology are a separate chapter that we can discuss later while we'll discuss about IPC. But we can relate always that this mental capacity, which is illustrated in section 12 of the Act, it talks about that the ultimate crux is that the person should be capable of understanding and making a judgment. If it is occasional, that at the time of the signing the contract, the mental capacity is important. If he is in his senses, the contract is valid. Now the next thing is the free consent, which was the first element, and this free consent is defined in section 14 of the Act, and this says that the consent is free consent if it is not caused by the 5 elements: coercion, undue influence, fraud, misrepresentation, and mistake. I'm repeating it. Section 14 of IPC, or Section 14 of Indian Contract Act, it says that the free consent, it should be free from 5 things. These are coercion, undue influence, fraud, misrepresentation, and mistake. Coercion is defined in Section 15, undue influence is defined in Section 16, fraud is defined in Section 17, misrepresentation is defined in Section 18, and mistake is defined in Section 20, 21, and 22 of the Act. So we'll take these all one by one, because this is a very important question when it comes to your exams or in the discussions or interviews, that what governs a free consent. So if it comes, you can say that first of all, free consent is a very important point for the essentials of a validity of a contract, which is mentioned in Section 10. Free consent is defined in Section 14, and the essential 5 components of the free consent has been defined in Section 16, 17, 18, defined in Section 15, 16, 17, 18, and 22, 22. You can still remember these 5 components with a simple phrase, which is CUFMM, which is can you forget my mistake. So this C stands for coercion, U for undue influence, F for fraud, M for misrepresentation, and M again for mistake. So as we seen that in Section 14, it says that the free consent, it should not be because of coercion, undue influence. Now this undue influence, the second one, it has been repealed in 1899 and it is added as 19A. So Section 16 is gone and it is added as 19A, and it is made a voidable option, not the void. So Section 19A says that the agreements which are based on undue influence, that will be voidable at the option of the party, one of the parties. Similarly, 19A says about the voidability of the undue influence. At the same way, 19 says about the voidability of an agreement when it is without the free consent. So now we'll go to Section 15, which is the coercion. Section 15 defines the coercion as, what is coercion? It is committing or threatening to commit any act which is forbidden as per Section 45 of IPC, or any unlawful detaining or threatening to detain any property to the prejudice of a person for entering into an agreement. So it clearly says that for entering into an agreement, if you are said that you use coercion, so there must be either a commitment or the threaten to commitment of an act which is forbidden as per the criminology, that is IPC Section 45, or any unlawful detaining or attempt to detain the property also for entering into the agreement. It comes under coercion. Section 16, undue influence. It's a very simple definition as per the Act. It says if you use power, position, or authority to gain an unfair advantage in a contract, it says that you used undue influence. So Section 16, undue influence says the use of power, position, or authority to take an unfair advantage in contracting is said to be used undue influence. Section 17 says about fraud, and then Section 18 says about the misrepresentation. These two are very important, and you should understand in parallel that what is the difference between them, because the demarcation is a very single line. Section 17 fraud says the governing idea of determining a fraud is the intent to deceive. Intent to deceive, the intention is important in case of fraud, and if such intention is not there, it comes misrepresentation. So fraud, as per Section 17, fraud is said to be committed when there is an intent to deceive, and in pursuance of that of achieving that intention, the person may do several acts. He can conceal the facts, he can make a false promise, he can do any fraudulent act or any fraudulent omission. So all this can be the part of his intention to deceive another party, and in such case he is declared to have committed a fraud. Section 18 says that the misrepresentation, it's not the intent to deceive in misrepresentation, it is a positive assertion. A positive assertion on some fact where you are not sure that that fact is true. You say something for a party to enter into an agreement while you are not sure what you are saying. It becomes a matter of misrepresentation, not fraud, provided it's not intentional and it is done innocently. So the stipulation in section 18 for misrepresentation is that it is a positive assertion when the person who's making it or committing it, he's not sure what he's saying is true, and it leads to a breach of the duty and it causes innocently a contracting party to make a mistake. Now the last element of making a contract or determining the free consent is the mistake. If mistake is said to happen, then the contract cannot be said that it is done with a free consent. So the mistake is mentioned in section 20, 21 and 22 of the Act. But before that, we should see a criminal law maxim related to the mistake, which says ignorantia facti excusat, ignorantia legis nemnem excusat. I'm repeating it. Ignorantia facti excusat, ignorantia legis nemnem excusat. It means ignorance of fact is excusable. It can be excused, but ignorance of law cannot be. This is the basis of determining the difference between mistake of law and mistake of fact in all the jurisdictions across the world. In India also, in IPC, this is a criminal law maxim. IPC takes reference of this, and even in contracting, the maxim has the effects. Because section 20 says that if both parties are under mistake of fact, not the mistake of law, then such contract becomes void. While section 21 says if both the parties are under a mistake as to law, not the fact, it becomes non-voidable. So the difference between section 20 and 21, it clearly says that section 20 says that the parties can be absolved from their responsibilities only it is confirmed that they are under a matter of fact. While section 21 says that if it is a mistake to law, it cannot be declared void, not voidable. Section 22 says that the mistake of one party as to matter of fact, again it becomes non-voidable. Now, we have seen the three important essentials. We have completed the free consent, which is mentioned in section 14 and the respective other subsections. Competency to contract 11 and 12, and then it should not be void, which is mentioned in section 23 to 30, 24 to 30, 32, 36 and 56 of the agreement. Now we'll go to the one which is lawful consideration and lawful object, the third and fourth essential. These two are jointly specified in section 23 of the Act. Section 23 of the Act says there is a 5 subclassifications to determine if a consideration or object is lawful or not. Section 23 says that the consideration or object in any contract is lawful unless, and there are 5 conditions. The first thing is that the consideration or object should not be forbidden by law. Means the law should allow such consideration or object. The second is it should not be of such nature that if it is allowed or permitted, it will defeat the provisions of law. It means it doesn't mean that it is forbidden by law, but it can, if it is allowed, it can generate something which will defeat the provisions of law. So this is again not allowed. If it happens, the consideration of object will be unlawful. Then it should not be fraudulent. It should not imply injury to a person or property of others. And the last one is it should not be immoral or against public policy as regarded by court. Here one important short answer question comes in your exam sometimes. What are the heads in Indian Contract Act which deals with public policy? So the answer to that is section 23, because we have just seen that section 23 talks about the consideration and object when it is unlawful. And the fifth component of this section 23 says that if the consideration or object is against public policy, it is regarded by the court as unlawful. So now the last point, the agreement should not be void. As we see in the voidability the condition, the definition is mentioned in section 2G. And then voidability with relation to contingent contract, it is mentioned in 31 to 32. But as an overall, we can see it now that what it is. Voidability, which is the fifth constituent of essentials, that it should not be there. It is described from section 24 to 30, 32, 36, and 56. So, what are the conditions of void contracts? Section 24, apart from this 23, which we have just discussed, which talks about that if any of the consideration or object of the contract, if it is satisfying these 5 conditions, which we have just discussed, it becomes void. So, apart from this section 23, now we'll go to 24, that which agreement is void. 24 says, an agreement is void if the consideration and object is unlawful in part. So while 23 talks about the lawful consideration and object as an overall, 24 says that if it is accepted in the contract in parts also, it becomes unlawful. Section 25 says that agreement without consideration is void. This is a very important point, section 25, and it can come as a specific short answer question also. That what is it right to say that agreement without consideration is a void? You need to comment. So here we say that section 25 defines what is a void agreement. The agreement without consideration is void, but there are certain conditions. That conditions we'll discuss now. The agreement which we are considering that without consideration is void, it will be considered void unless it is registered in writing. First point is unless it is registered in writing, or it is a promise to compensate for an act which is already done, or if it is a promise to pay for a debt which is barred by limitation law. So these 3 conditions, apart from these 3 conditions, any agreement which don't have any consideration, it becomes void. While under 3 circumstances, the contract without consideration also will be considered as an agreement or a valid contract. And these 3 are, I am repeating it, if it is registered in writing, if it is to fulfill a promise for compensating a person who has already executed or worked or given you your services, or if there is any long old settlement and that is limited because of the provisions of the limitation law, then you can make a separate contract to pay any debt related to that previous agreement. Section 26 says that the contract in restraint of marriage is a void. Restraint of marriage means which limits the freedom of a marriage is void. Section 21 says that the contract in restraint of trade is void. Section 28 says the contract which is in restraint of legal proceeding is void. So 26, 27, 28, they just simply says that any contract which is in restraint or limiting the freedom of marriage, trade and legal proceeding respectively is void. Section 29 says that the contract void for uncertainty means where the agreement of the meaning is not certain, then the contract itself becomes void. Section 30 says that the agreement by way of wagering, which is bet, it becomes void. Section 32 to 36 says the contracts are void in relation to contingent. As we seen in the second lecture, that section 32 says that the contract which is contingent on an uncertain event, and in case that uncertain event becomes impossible, the contract becomes void. Section 36 states that the contract which is contingent on an impossible event, it becomes void ab initio. Section 56 says that an agreement to do an impossible act, the contract becomes void ab initio. So these are the voidability constituents. So now I'll wind up this. So in this, what we just a small recap. What we've seen today is section 10, which is the essential of the contract, where we have seen the 5 components, which is it should be free consent, it should have capacity to contract, then there should be a lawful consideration, lawful object, and should not be void. Then for all these 5 components, we have seen their section wise descriptions, their definitions, their conditions, and then we are finishing it now. I hope you would have understood it to the best extent. If there is any doubt, you can make a comment in the comment box. So we'll continue in the next lecture. Thank you, bye, and take care.